All right. Okay. Thank you very much. Okay. Here we are on talking about one of the most important issues in one of the cornerstones of the multilateral trading system, the most favored nation principle. Actually, a few years ago, it would have been a sort of scandal to question the validity, legitimacy, or importance of the MFN. Today, it's not only debated, but openly challenged in some quarters. For this discussion, we have distinguished professors and active MFN practitioners, all friends with long CVs on related trade issues. We have already received their bios. You have received their bios with the invitation, but I'm going to give a short version of them. So the conversation will start with Gabrielle Marceau. She worked at the WTO over 30 years, serving as a legal advisor in international dispute. Many of us had the privilege of counting her as an advisor in different panels. For many, she was and still is a sort of legal guru on WTO matters. She also, today, she's a lecturer at the University of Geneva on WTO law, but she's also a visiting professor at numerous academic institutions and member of many international societies. As a matter of fact, I understand Gabrielle now is visiting the University of Ottawa, and she has more than 125 publications under her name. Huge. Then will come Maria Pagan. Until January last year, she was the ambassador of the United States to the WTO and naturally the deputy USTR. Before that, she served as the USTR senior officials in various multilateral fora, such as G20, G7, and previously, she was the Deputy General Counsel of the USTR, providing legal advice to senior officials on all legal aspects on trade negotiations, implementation of trade agreements, and trade-related legislations and regulations. In those days, I had the pleasure to meet her for the first time. Prior to USTR, Maria worked as an attorney advisor in the office of the Chief Counsel of International Commerce at the Department of Commerce, the DOC. Then will come John Clarke. He's a former director of international affairs in the European Commission, DG Agriculture. In that role, he focused on the EU enlargement and multilateral negotiations with industrialized countries, as well as Asia, Africa, and Latin America, including free trade agreements. Prior to this, he was head of the EU delegation and on the so-called blue box, that is the building of the EU delegation to the WTO and the UN in Geneva. He joined the European Union in 1993 as a trade negotiator. Before that, for 10 years, John held various official roles in the Hong Kong government. During that time, the stormy days of the Uruguay round, I had the pleasure of being acquainted with him and his family. And last but not least, Wenhua Ji. He's a professor at the School of Law, University of International Business and Economics, UIBE in Beijing. Actually, this was one of the first universities to start with programs entirely in English in China. He has written extensively on international economic law, trade law, dispute resolution, global economic and trade governance, commercial transactions, and naturally, WTO dispute settlement. Currently, he is the co-chair of the WTO Chairs Program at the UIBE. Previously, he worked at the Ministry of Commerce of China and the Chinese mission to the WTO as a legal officer. He has been involved in legislative processes of several laws and regulations on trade and investment in China. So this is I would say, the substantive, our panelists. Each of them will have around 10 minutes to present their views, and then we will have The rest will have around half an hour or so to discuss, to pose questions and make comments. So Gabrielle, you can start. No, you're muted. Yeah.
Thank you, Mario, for inviting me. You've asked me to make a short presentation, which I will do, and I will share a paper. I have to say that I'm very honored to be here. I was even uncomfortable speaking before Maria, John, and Wenhua, but I do it more from an academic perspective. So I share the document for now. Do you see it well?
Yeah, perfect.
Okay. So what I'll do in my 10 minutes is just to describe a bit from our research the origin of this principle. And in the second part, the application in GATT, WTO, and the numerous exceptions. I will not issue or make any comments on the current proposals. I just made sure that I was describing everything so that the subsequent speaker can explain. So we have, just before I arrived, John was saying that everybody knows about MFN now. It is correct. And I was myself surprised to see that it goes back to many years, like almost 1,000 years back, where the concept of MFN was used as a promise at the time, either by cities, merchant, it varied, even countries, because a few countries existed, where essentially one country would promise to another one city to another one, that any benefits it receives, it would then pass them, the third entity would get them. There is an issue that keeps coming back, whether MFN is applicable only to benefits, to advantage, to privilege that you give or those you receive. What is clear is that MFN does not apply to obligation, only to privilege. And still today, it's not customary international law. It is something that was at the time negotiated and in times of war imposed. So, for instance, I put on the screen the language of this old Charter of Mantua, whereby the city will offer to merchants of all other Italian cities the rights that it gives to other city outside Italy. And this continued, you will see, until the GATT WTO. But as things evolved, the MFN got a bit more refined to become more generally a two-way promise written in treaties. And then you have the example in the third bullet point of East India Company, which was those who developed for the UK, for England. And this treaty is between this company and Burma. And you see, if the king shall hereafter grant any more or other privilege to any other nation, the same privilege are to be granted to the English. So it's a commitment to give to one what you gave to other. Of course, there's the situation of war, and apparently it existed with the Ottoman Empire a lot, where depending on who wins the war, the winner requires to have access to all the privileges of the loser. And as it's mentioned here, apparently, but this is secondary and the third sort of literature, Europeans did not always return the favor. But it shows a part of imbalances when it's not reciprocal. MFN can also be conditional or unconditional. And in the example on the screen, the UK France, this is an example of unconditional. But there's always this idea of existing privilege that you may pass, or only future, or only some of them. But on this one, I highlighted the standard language, any favor, privilege, or reduction in tariff or duties which one has, it will concede to a third one. I put in bold or fat the rest because to me it was quite interesting. In that treaty, it applied not only to duties or access, but prohibition of importation and exportation. I'm not sure it exists still today. Many have heard about the US-Mexico. At university, we learned that this was a bit of a model used at the time of GATT or even before. But you see, again here, the merchants of each nation shall enjoy basically the protection and security already enjoyed by the donor. Shall not pay higher or other duties, fees, whatever, than those, and we use the expression, which the most favored nations are or may be obliged to pay, and it shall enjoy all rights, privilege, exemption. There it was navigation and commerce, etc. So the conditional MFN, you've understood what it is. It's that you can give it, but at certain condition, at certain time. And in the US-France treaty, it was a commitment that not to give it unless you receive. So shall enjoy the same favor freely if the concession was freely made, or on allowing the same compensation if concession was conditional. All this is sort of a quite understandable. What is impressive is how it's been used, again, on a negotiation basis throughout history. I refer now to between the two wars, after the First World War, where it will expanded. And the example here is the Traité de Versailles. Every favor, immunity, or privilege in regard to importation, exportation, or transit of goods here shall simultaneously and unconditionally, without request and without compensation, so quite sort of automatic, be extended to the Allied. Between the two wars, there was an effort to, and after that, again, the ILC, there was an effort to try to codify that, try to understand what it is. The only thing we found is the Institute, and basically it just brings it back to a trade issue, merchandise and navire, boats of a third country are entitled to the right given internally. And this was done, the effort to try to reduce ambiguity. I'm not sure it was successful because afterwards, this is much after the two wars, the ILC had twice, and we focus on the one on 78, an effort to try to see what MFN is. What is certain is that MFN is not customary. It exists only if you negotiate it and put it in treaties, although it's been used often, and often in investment treaties. So this group went into looking at different clauses, but again concluded it's only treaty-based. And then comes the GATT-WTO. So Article 1 of the GATT, which is now a component also, as you know, of GATT 94 and the WTO, has the wording that we know. It's applicable both side, importation and exportation. What is important is that it applies to a long list of things. We always talk about duties or tariff, but it's much broader. So I just read out customs duties and charges of any kind imposed on importation or exportation, but also international transfer of payment, again, imports, exports, method of living, duties and charges, and all rules and formalities, again, with respect to import and export, quite broad. Very important. And we'll see in one of the proposal is relevant on that. It is applicable to everything covered by Article 3.2 and 3.4. That is all taxes, matter, fiscal, and regulation. So MFN is not only a border principle, it is also for all internal. And time is running. So I'll go quickly. There are several exceptions to MFN, including the general exception, which itself, Article 20 Chapeau, has some sort of MFN. We call it a soft MFN, that is a right to discriminate if you have a justification, and between countries where the same conditions prevail. There's, of course, the security exception. There's a long list of exceptions in favor of trade from developing countries, from the 71 waiver to the enabling clause, and to what we call nowadays the super enabling clause. That is the provision, the decision in the WTO that allows the poor developing countries to give to the very poor in a specific manner. There are also, of course, possibilities of agreed and voted waivers where MFN would be violated or set aside. There are, of course, also regional trade agreements, which are exceptions to MFN because you treat better at certain conditions the country with which you have a free trade agreement. And there's a special exception for regional trade agreements in the enabling clause between developing countries. It's also interesting to see that the case law has interpreted the right of giving preferences to developing country. This right, given preferences given by rich to poor countries, can include conditions, so long as these conditions are about development, are applied objectively, and similarly situated developing countries are treated similarly. So we recognize, again, a lot of possibility of setting aside partly or conditionally MFN. We have plurilateral agreements, the formal one of Annex 4, and there are the de facto one that are ongoing at the WTO. There's a debate whether those formal plurilateral are really perfect exceptions to MFN for those who are not party. Many countries believe that they are. That is, the rights and obligation of a formal plurilateral are applicable only to those who sign the plurilateral. If it's not, and in my view, it is written in the WTO, if it's not clearly written, we could argue that because MFN is almost a superior provision, and what I forgot to write on my way running back here, I remembered that amendment to Article 1 and 2 of the GATT in the WTO can be done only by unanimity. So it proves again how important it is. Now, there are other MFN provisions than Article 1. You have them in balance of payment. You have them in Article 13. There are exceptions to that. The general exceptions, the waiver. There's also an MFN in the transit provision of the GATT that says that, all countries should be imposed the same sort of reasonable cost for this transit. And there is a long list of MFN across other agreements in the WTO, starting, of course, by the GATS, with some sort of adjustment. For instance, the GATS provide in Article 2 MFN, that is one privilege or access that you give to one country, you must give to the others. But the GATS has exemptions, which allows a country to continue to treat better a country imports or transactions from a country with which you already had a deal before you joined the WTO. There are regional trade agreements, and importantly, you have mutual recognition possibility where two countries recognize each other's regulation or provisions without doing the same with the provisions from another country, although similar situations should be treated similarly. And of course, you have the general exception, security exception. TBT has a form of MFN in its first provision, doesn't have formal exception, but the jurisprudence has read the obligation of non-discrimination in TBT in allowing regulatory distinction between similar situations, if and only if it's based on legitimate objective and so long as it's applied even-handedly. These are all situations where the MFN is not perfect. TRIMS, the investment agreement, basically brings on board all the exceptions and doesn't have an MFN, but it has an Article 3, which, as we mentioned in the very first page, is 3.2 and 3.4 are sort of covered by MFN. SPS has a special, also non-discrimination. TRIPS, this is one of the distinction between many of the WIPO treaties that were imported into the WTO. We added, not we, but the governments added a clear MFN obligation with some sort of possibility of exemption and exceptions. The last point for 2 minutes is just to repeat and give a few statistics. According to WTO, the average applied MFN tariff declined by more than 40% since the WTO, essentially. And this has led, of course, even with the disruption of 2025, it is reported that 72% of global trade is still conducted under MFN. Personally, I'm not entitled really to have big opinions on this because I'm not an economist. I was quite surprised because whatever you think of the deal or its components, all the deals, let's say even the regional trade agreement between India and EU and India and US and the deals US-EU, this has, I think, eaten up a good part of the MFN sort of trade so far. And that's the point I make after. There were quite a few disputes. MFN is traditionally the backbone, so it's part of many claims. Now, my two last points concern a bit more economics. So why is it so good? The economist insists that if you liberalize trade between a subset and you trigger or that leads to lower domestic price, extending the same sort of lower tariff to all suppliers will preserve outsiders' competitive position, some sort of fairness. There is, of course, a risk of free rider because the negotiation is often between two and the privilege is given to a third that may not give. And that's what is happening at the moment, according to some, may not give anything in return, the third entity that benefits from the MFN. And this is what some people say should be the basis for reconsidering flexibility or new rules. I would like to insist again on MFN is not only a market access issue, it covers all regulatory provision, hence the importance of things like equivalences, mutual recognition in the system. I finish, we can talk more about it. Of course, MFN is linked to other things. It's linked to subsidies, it's linked to other activities, to other principles. I put here a quote of my previous boss, Ralph Ossa, about the issue of China, which you may want to discuss or not, but essentially his point is that if a player doesn't play by the rule in one area, stopping MFN may not be the solution. And me as a lawyer, I just said, yes, but in international law and state responsibility, if a player, if a partner, if a treaty partner does not respect the treaty, you're entitled to violate another treaty provision. This is not permitted because of the Article 23 of the DSU prohibiting unilateral action, but conceptually it can make sense. Thank you.
Thank you, Gabrielle.
Sorry, I was speaking too fast, maybe.
No, it's okay. It's okay. It was a comprehensive presentation of the issue that will give us a lot of food for thought in general. But now, Maria, it's the time of Maria. You have the floor.
Well, thank you. And thank you for that presentation. You know, this is the second panel like this on MFN that I do. And I was wondering, why do we go back to long history of MFN. Anybody who cites any treaty between the UK and France anytime before World War I think like, but yeah, look at history. But anyway, setting that aside, one important point, that you made, and that I think is important to keep in mind, is that MFN is not customary international law. It is agreement-based. It is treaty-based. And I do think that that's important. Anyway, I've been asked to present, I guess, and on the U.S. communication from back in December, I think it was, that includes something on the notion that we should be rethinking MFN. I think that setting aside the Trumpian rhetoric of everything that comes out of the Trump administration, there is very little that is new in that U.S. communication. But I will set out what the paper presents, and so this is I'm just relaying what the administration is saying, and then I will also have some comments that are from my own perspective. But I think that, and I think Gabrielle's presentation is useful. The way the United States looks at this is, yes, MFN is an important principle, but it's not the only important principle of the WTO compact, or the whole WTO framework. It was intended and is intended to promote equal treatment among the parties, but it was intended to do that during a period in which those parties were also expected to adopt open, market-oriented policies as they implemented the various WTO commitments, which include MFN, but include many others. I should step back and should have said this, kind of jumping around my points here, that the US paper and the US criticism of MFN is very, very much focused on tariffs. And, as Gabrielle mentioned, there are many other elements of MFN that I don't believe this administration has issues with. And so I just want to be very clear that, as she said, there are many other elements to MFN, but as we all know, the Trump administration is very, very much focused on tariffs. And so again, you have this principle of equality, but another very important principle for the United States, and this is not just for the Trump administration, this is really for prior administrations, which the United States considers to be also a foundational principle, is again the market orientation. It is right there in the Marrakesh Declaration. It is the foundation. Actually, the declaration itself states that participation in the world trading system is based upon open, market-oriented policies. So while it is not reflected as a specific commitment, as MFN is, Article 1 of the GATT, it is foundational. So again, I think people who've been following this issue know and understand sort of the way the Trump administration looks at this is, yes, there was tariff liberalization. Yes, we all made commitments at the beginning of the WTO, but only some of us continued liberalizing. And then this other part of it, this market orientation side of the foundational principles, has not been met. So again, in the Trump administration view, this has led to trade imbalances. Again, looking at it very much from the tariff perspective, leading to adverse effects in, again, looking at it from is there a trade deficits in the deficit countries, and that needs to be corrected. I'm not gonna. The paper also recognizes that there are exceptions to MFN, again, making the point that MFN is not this one solid principle that has no exceptions. The paper mentions the enabling clause. Gabrielle has noted that. And I think you also have to understand the US position, not just, and when you read the US communication, not just looking at the MFN portion, but the special and differential treatment portion of the paper, because these things are all linked together. So on the one hand, you have a system that recognizes that you can have special and differential treatment. You have the enabling clause allowing for, very laudably, for preferences for developing countries. And the United States, again, does not dispute that developing countries may require special and differential treatment. The problem comes with when you have a system that is based on the self-declaration, as we have in the WTO system, and where we've become ossified in the basket in which we place countries. Because while let's park the, LDCs can graduate, but they graduate to being a developing country. So let's, set that aside. But nobody ever graduates from a developing country to a developed country. And again, it's an objective fact that even in just the 30 years since the WTO came into being, there have been improvements. Again, I'm not going to go debating on who should, be classified where, but it really has led to this, okay, the United States does recognize that there should be special and differential treatment, but it cannot be that forever and ever and ever, you have this two sets of members, one being the majority of the members of the WTO that, by right, as some of them say, as they say in the General Council, deserve to be treated specially forever. Again, this is really the U.S. view, but I do think that, the United States has presented papers on there should be a way, like most other economic international organizations, to distinguish, between countries. And I think the couple of other things I would like to mention that were not expressly mentioned in the U.S. paper, in addition to the enabling clause, and Gabrielle went into this, we have the GATT Article 24, which is for the free trade areas and customs unions. So that's a huge exception of the MFN principle, which is used a lot. Again, how much do people really love MFN? By the WTO's own count, and this is just some information that they have available that they've been able to find, there are 346 FTAs or customs unions. 346. Again, those are just the ones that have been notified and that they're aware of. And whether all those agreements meet the requirements of Article 24 is something to be debated. If you add the GATT's Article 5, which is the equivalent of GATT 24, and enabling clause arrangements, again, by the WTO's own count, there are 628 such arrangements. So again, we love MFN, but we also love to get around MFN. Then the second point I'd like to make, and I think this is the one where we really, if you like the system, if you want the system to move forward, I think we do need to engage in this conversation, is MFN is intended to prevent arbitrary discrimination. And that's a very laudable goal. But in today's world of interconnectedness and global challenges, WTO members really need to be able to take measures to address legitimate goals. And sometimes that can only be done by differentiating, not discriminating, but differentiating between those that are playing fair, those that are not playing fair, those that are promoting goals that are shared. Gabrielle rightfully mentioned there are exceptions. But I do think that there is a rethink that needs to be done to see, how all this is playing together to allow countries, WTO members, to do things that are legitimate, that they need to do, because they also, again, all governments have to be responsive, not just to the international community, most importantly, to their citizens. So I think that, I hopefully continue having these conversations and looking at these issues, not just thinking about MFN, the MFN discipline itself, but all the other things around it. Because I think, again, from the US perspective, and I very much agree with this, you can't just say MFN is this thing that has been around forever and ever. And lots of things have been around forever and ever, and we should get rid of them. I'm not saying that we should get rid of MFN completely, but we need to rethink, because there are other things that are, in my view, equally important and as foundational for the WTO system and for the system that we may want for the future. And so we need to see how those things are interacting. Again, whether it's looking at exceptions or whether it is really looking at where the membership is in terms of who has impact on the world economy and world trade? And are those who have more impact, should they have more responsibilities or be subject to more safeguards? I mean, those are all conversations that I think, we need to have. Also, do we need to make it easier to rebalance concessions? That's another thing. We haven't quite, hit on that yet. But and my final point, and again, Gabrielle, thank you for including this, is plurilaterals. Most WTO members are saying, and certainly the United States is one of those, are saying plurilaterals is the way forward for the WTO. What are plurilaterals? Exceptions to MFN, they can be. So again, I think we just need to, I know it's hard to set aside and park what the Trump administration is doing when we have these conversations because it's so glaring and it's so in your face. But I do think that we need to try to have at least, criticize the Trump administration if you want, but at least also, try to be intellectually honest as we try to move forward. Thank you.
Thank you very much, Maria. Very clear. We are all saying that MFN is good, but not necessarily we are applying it or using it in the proper way. Okay, John, it's your turn.
Well, thanks very much, and thanks to Gabrielle and Maria for a lot of food for thought. For those of you expecting me to defend the EU's recent proposals on WTO reform and MFN, I'm going to disappoint you from the outset. And that's because, as you mentioned, Mario, in the Uruguay round, I was one of Hong Kong's trade negotiators, and representing a small to middle-sized economy, preserving MFN was really an existential question. It protected us from the law of the jungle. So we fought for MFN in the safeguards area, where the EU wanted to impose selectivity. Above all, we fought for MFN to stop US unilateral measures. And a big achievement of the Uruguay round was, of course, getting the US to agree to multilateral constraints, including MFN, no more 301. So I'm a great supporter of MFN because it's essential for smaller countries and smaller companies to have the transparency and predictability that it gives to the border treatment of their exports. So it's actually, among other things, a major trade facilitation measure. It's the main binding rule of the WTO system and a bulwark against protectionism. And as sort of Gabriella hinted a little bit, it has a significance well beyond trade, because non-discrimination is the basis of most of our values and laws. Non-discrimination as regards race, religion, color, gender, sexual orientation. WTO MFN doesn't operate in a vacuum. I think that's an important point. Now, the EU, following the US and more recently China, has tabled for MC14 a proposal to reform the WTO. And on MFN, the EU says we need to revisit it because the balance of rights and concessions struck in 1995 is not the same as today. In short, developing countries who were poor in 1995 and didn't have to make many tariff concessions are now far better off and should open their markets more. And if they don't, then the EU and other countries should have the right to withdraw MFN treatment to those countries who don't provide a level of market access that is commensurate with their trade competitiveness until they open their markets more, until we find a new balance. Now, I'm not wholly without sympathy for the EU position, and it's true that some emerging economies like China, India, Brazil, others could open more because they've been quite successful. Although in the case of China, they don't pose tariff barriers, but rather they export with unfair trading practices. But I don't think that reopening, let alone ditching MFN, is the right antidote to this problem. And I say this for several reasons. I've got 5 reasons, basically, why we should be very careful before we question the validity of MFN today. First of all, we should welcome the fact, I think, that many developing countries have become more prosperous. That's what the Uruguay round was meant to do. We should not give the impression that we want to move the goalposts, as it were, the moment that the other side gets into the penalty area. More generally, is it the right approach to change the rules that have led to global prosperity at the moment they don't suit you. Secondly, I think the US and EU proposals to revisit MFN are going to be read as an attempt to get some kind of ex post multilateral blessing on the illegal MFN denying deals that the USA has been coercing other countries to swallow. Thirdly, as Gabrielle set out very well, there are many, many exceptions already to MFN, from national security, Article 20, RTAs, the enabling clause, and of course the possibility to discriminate against products coming in via unfair trade practices like dumping or subsidies, which can of course help deal with the perceived China problem. So there's a lot of flexibility in the system already. Fourth reason, feasibility. Irrespective of the intellectual case or lack of for modulating MFN, the EU's proposal is politically, in my view, a non-starter. Most WTO members will simply not agree to review MFN because they have no incentive to do so. You know, WTO negotiations are driven by incentives, and unless and until the EU puts agricultural market access on the table, there'll be no negotiations on tariffs to rebalance this apparently unbalanced Euroground outcome. And fifth and finally, timing. A month before MC14, and at the moment when Trump has taken a wrecking ball to MFN, I think it's quite myopic for the EU to question MFN if it genuinely wants to start a civilized debate on WTO reform. Surely this is the moment to actually reaffirm MFN rather than undermine it. And frankly, nothing can be more guaranteed to prevent a reasonable reform debate than the EU putting this on the table. It's ironically given China a free pass to occupy the moral high ground with a very clever submission on reform, which defends MFN. So I don't understand, frankly, why the European Union or the Commission didn't hold fire on this particular issue, or at the very least, use less inflammatory words. One could almost think that somebody in the Commission put the MFN words and the idea into the EU proposal in order to kill the whole reform debate. So to paraphrase the remark from Dr. Johnson, seeing the EU put forward a proposal to revisit MFN is like a dog walking on its back legs. It doesn't do it very well, but you're surprised to see it doing it at all. But the problem predates the current US administration. As you know, the EU and the WTO are in some ways mirror images of each other. The Euroground rules were partly shaped by, and certainly they shaped a lot, the European single market. And MFN and its sister national treatment are the basis of the European single market. And 2 years ago, the EU allowed some member states to fundamentally breach single market rules and the MFN principle by allowing the unilateral blocking of Ukrainian imports. And instead of taking those member states to court, the EU blessed that treatment and still are doing. And of course, more recently, the EU breached MFN by condoning the US illegal tariff of 15% on EU exports, but also, more importantly, by giving the US tariff-free treatment, and only the US tariff-free treatment for industrial goods. So all this to say that EU credibility on MFN is a bit low at the moment. So I think a lot of the world in WTO will view rather cynically the EU's proposal on MFN. And I doubt that most developing countries will want to get into this kind of discussion, especially when it's linked to other ideas, such as revisiting SDT, setting up a WTO steering group, moving away from consensus decision making. For some countries, this is potentially quite a poisonous cocktail, which may confirm to them that the EU has not really changed its spots. So my parting remark would be that we should be very careful with this issue. We should abandon MFN at our peril, particularly from the EU perspective, if the EU is very slowly moving from, if you like, great power status to middle power status, it's going to need MFN more than ever. I quoted Dr. Johnson. I'll end with a quote from Joni Mitchell in her song Big Yellow Taxi, which I think is a good warning about the danger of questioning MFN. Don't it always seem to go, that you don't know what you've got till it's gone? I'll stop there. Thanks.
Thank you, John. As usual, very entertaining, your ending. And now the time of China. Wenhua Ji, you have the floor.
Thank you very much, Mario. Can you see the screen I shared?
Yes, it's okay. Yeah.
Okay, thank you very much. The previous speakers have made very thoughtful and good remarks. So as the final speaker, I would like to share 4 observations on the WTO reform and the MFN principle, drawing on the recent reform proposals submitted by China and the United States and the European Union. I've prepared this very brief PowerPoint to guide my presentation. The first one, because China's paper, this paper was just tabled several days ago, so I would like to have a very brief overview. China's position paper is very concise, only 2 pages, 11 paragraphs. Compared to the lengthier US and EU submissions, it is more compact, but its scope is equally broad. It covers governance, MFN, development, and dispute settlement, etc. So what it does not do is elaborate in great detail. It is a statement of positions and not a program of negotiations. So the paper has 2 parts. The first part covering paragraph 1 to paragraph 6 set out China's general assessment of the WTO and its reform principles. China acknowledged that trade tensions are rising, but argued that the WTO rules and mechanisms remain a vital shield against the trade turbulence. So China thinks that unilateralism and protectionism are not the answer. China also include a very brief sentence to rebut some blame related with China. So blaming the so-called foreign unfair competition shifts attention away from domestic reform that is necessary to unleash competitiveness. So that's the general position. And the second part, 4 paragraphs from 7 to 10, set out China's work proposals for the reform process, include development on decision-making, on fair competition, on dispute settlement. So this is a very concise document that include the main ideas from China's perspective. So I would note that this paper represents China's first comprehensive systemic statement on WTO reform since MC 12. So it responds directly to the expectation that arose, particularly among developing countries, after the US and the EU respectively put forward their proposals on the table. So that's a very general overview of China's paper. The second point is China's position on MFN stance. On MFN question specifically, China's paper contains just 1 sentence. The MFN principle shall remain the bedrock of the WTO. It is very brief, but it is not without a meaning, I think. So reading it together with the surrounding paragraphs, China's position becomes clearer. Because China's paper states that WTO reform should aim to reinforce global trade governance that is universally beneficial and inclusive, and that an open, fair, non-discriminatory, and rule-based international economic and trade order serves the interest of all members. So naturally, MFN is in this framing is a fundamental commitment. So that's the reason why China only include 1 sentence on MFN. From a legal and textual standpoint, I would like to offer 2 readings of this sentence. Of course, purely a personal opinion. First one is China will not accept any proposal that substantially weakens or effectively eliminates MFN as a binding obligation at the WTO. So that's my reading from the China's position paper. Second reading is that, well, perhaps more nuanced. The phrase shall remain the bedrock, but does not amount to a categorical rejection of all discussions. So it leaves some room, maybe narrow room, for technical or circumstance-specific adjustments, provided that the core principle is preserved. So this is a position of principled flexibility and not absolute rigidity. Finally, I would like to share, with that context in mind, I would like to raise 5 questions that I think deserves more careful consideration as this MFN debate may unfold in the future. The first question is, so what exactly is the objective? Because the US and the EU proposal call for some form of MFN reflection or recalibration, but neither is entirely clear about the intended outcome. Is the envisioned adjustment fundamental? Fundamental means the removal or effective suspension of Article 1 would get, or is it technical or incremental, such as expanding the category of MFN exceptions or lowering the threshold under Article 24 for regional trade agreements? It's not clear. So these are very different propositions with very different consequences. So until the objective is clearly defined, it's difficult at this stage to assess whether the proposed reform is proportionate or even coherent. So the second question is why limit the discussion only to tariffs? And I think Gabrielle also mentioned much about MFN covers a lot, not only applies to tariff, it applies to many things. So much of the current debate seems to focus on tariff liberalization in goods trade, and specifically on the argument that some members have benefited from MFN treatment without reciprocating sufficiently. But as we all know, that MFN in the goods trading goods context applies to far more than tariffs. It extends to procedure issues at PF, TBT, licensing procedures, and many other areas. So if a member is permitted to deviate from MFN in response to perceived tariff imbalances, what principled basis is there to prevent it from taking non-MFN measures in those other areas as well? So the logic of selective deviation is difficult to contain once the discussion is open. The third question is who actually bears the consequences? Well, the 2 proposals from EU and the US respectively appear to assume that relaxing MFN disciplines to some extent will constrain that relaxing MFN discipline will constrain the behavior of other members, and in particular, large developing economies. But I think this is a two-way street. Once MFN is no longer a binding obligation, other members, including emerging economies with significant trade leverage, are equally free to take discriminatory measures unconstrained by existing WTO rules. So the retaliatory capacity of major developing countries is not trivial. So I think the strategic calculus here seemed underdeveloped in the current proposals. The fourth question is why only trade in goods, not a service or IP? Developed countries generally have not proposed reconsidering MFN in services or intellectual property protection. Yet in both of those domains, it is the developed world that holds substantial surpluses over developing countries. I think this is a fact. So if the logic of fair reciprocity justify MFN recalibration in trading goods, the same logic would apply in services and IP in the other direction. So this once the process of MFN recalibration is opened in one domain at the WTO, it is generally difficult to argue why that process should be confined to only in goods. So the fifth question is perhaps the most important. Who need MFN most at this junction? So let me conclude this with a broader observation. MFN has served as a structural constraint on the behavior of powerful members for decades. For large trading nations, this constraint may feel limiting, but for small and medium-sized WTO members, MFN is something quite different. It's a kind of protection. I think John just take the same similar position on this issue. It ensures that those small or medium-sized WTO members, their access to markets and their treatment in those markets does not depend on their relative bargaining power or political relationship with larger partners. So I think for middle and smaller members, a world without MFN is not a world of better bilateral deals. It's a world of greater vulnerability and more exposure to economic coercion. Indeed, the current reality we witnessed in the past several months indicated that maintaining MFN as a fundamental principle of the multilateral treaty system not only benefited the entire multilateral treaty system, but is also an immediate necessity for the vast majority of small and medium WTO members. So this concludes my presentation. I look forward to discussing it. Thank you very much.
Thank you very much, Wenhua. Actually, these 5 questions, I guess, will be used for the comments later on. Okay, we finished the presentations and the floor is open. Raise your hands who wants to make a comment or pose questions. Hamid, you have the floor.
Thank you, Mario. Can you hear me now and see me?
No, it's too low. Your mic is not. It's like in the last meeting that we had. You have to do the same.
Low? Is it still low?
Very low.
No.
Okay, take another question, and while I fiddle with my laptop and see what's wrong. All right.
Sorry, I didn't understand what you said. But Victor
Dobrado, someone has to make a question and he'll try and sort it out.
Okay, so Victor Dobrado is saving you.
Yeah, thanks, Mario. Hello to everyone. Great presentations. Congratulations to all of the ones who spoke. I guess my point is something that has not been really talked about much. I think Wenhua said something about this, is who is actually asking for non-MFN? Who's asking, who are the demandeurs for the US and the EU to abandon MFN? Because the way I see it, MFN has really helped the business community. Most of the businesses actually like MFN. It's practical. Gabrielle raised the number, 72% of world trade is still done on MFN basis. So clearly those economic agents who are engaged in exportation and importation find it useful to have an MFN tariff. And we know how political this is, but I wonder whether the business community wouldn't find it prejudicial to their interests if MFN were to be sidelined. Thanks, Mario, and congratulations to the presenters again.
Thank you, Victor.
Sorry. Can you hear me clearly now?
Yeah, perfect now.
All right, thank you. And thank you, Victor, for saying. Thank you so much for the presentations. I think there's a lot of food for thought there, but I'm not going to get into the political economy of it or the systemic imperative of having MFN, but I think it might be a very healthy thing to have a real conversation about what MFN means. And thank you, Gabrielle, for providing the introductory presentation. Point number one, and I think, and please for the panelists, please disagree with me if you think of what I'm saying is wrong, because this is also in the form of questions for you, whether you agree with what I'm saying. First of all, I like very much what has been mentioned about this is not just about tariffs. And of course, the last point about services, Wenhua is quite right. I think the world of MFN application with all its complexities really mushrooms when we look at services and particularly the level of domestic regulation. So it's not just about tariffs, because tariffs gives us a very narrow picture of how MFN applies as a legal principle. And the second thing is what MFN means also. Through the application of MFN on regulatory matters in particular, we've come, even through our jurisprudence, we've come to the conclusion that MFN really is not about guaranteeing identical outcomes, not guaranteeing identical trade outcomes. It's about guaranteeing equal opportunities. And equal opportunities are always defined in terms of what the domestic regulatory mechanism in each country offers by way of opportunities. It is those opportunities that need to be offered on an MFN basis, equally, equal conditions of competition, so to speak. So in agreements which and this is explicitly in the GATS, for example, recognizing the right to regulate, and the GATT itself also recognizes that right, not that explicitly, but that's why we have the TPT and the SPS and other legal instruments to ensure that while regulators exercise their sovereign duty, they do that in the least trade restrictive way. Anyway, but if this is how we understand MFN, then I like very much what Maria said about distinguishing between discrimination and differentiation. Because MFN prohibits discrimination, but it does not prohibit differentiation. As long as you apply the same set of objective criteria to everyone. And you will find this, for example, a good example of that, you'll find it in Article 7 of the GATS on recognition, where it allows for the recognition of professional qualifications, recognition for licensing or certifications in different jurisdictions, or even the recognition of regulatory standards. But with the condition that the criteria you apply to grant that recognition is applied on MFN basis. So your regulation needs to be applied on MFN basis. You have the right to differentiate because if you have a set of regulatory conditions for accessing the market in one sector or the other, that's your sovereign right. Some suppliers might make it, some might not. But in making those distinctions, you're not violating MFN. So I think we really have to be very careful about how we define the MFN as a legal standard and what it means in terms of its application to regulatory practices. And then we will clarify the margin of differentiation. Thank you, Maria, again. As opposed to discrimination. When the EU applied their GDPR regulations, apart from the conversation of whether there may be some discrimination on the margins or whether it's fully consistent with MFN, but the principle itself, to have your own standards of protecting privacy and personal information, having your own standards and applying them to everyone, that's not a violation of MFN. It would lead to different outcomes with different partners and different market operators. But that differentiation is not discrimination. And I think this point is very subtle, and it always escapes public conversations about MFN. But I think it is key to clarify that so that we know, first of all, what we're applying, MFN, and more importantly, we have a good diagnostic view of where the problem is, because the problem might actually not lie in ditching MFN. and even compromising the status of MFN as a core principle. Now, I'm not prejudging the outcomes of that conversation. I'm only saying we need to have that conversation. But please disagree with me if you think I said something wrong. The other thing I want to also clarify here, and again invite disagreement, is there is a distinction, I think, between MFN as a standard by which country A has to treat everyone else the same, and the concept of special and differential treatment, which relates to the level of commitments or obligations that country A assumes. Because special and differential treatment, apart from the enabling clause, because the enabling clause actually relieves developed countries from MFN in order to grant concessions. That's a different story. I'm talking about developing countries enjoying flexibilities. And I say flexibilities here because in the GATS, you don't find S&D. There's no S&D in the GATS. And it operated very well and has always been recognized as one of the most development-friendly outcomes of the Uruguay round. Why? Because we moved from the one-size-fits-all to the individual flexibility, customized outcomes. But that special treatment or that flexibility does not automatically lead, or does not even ever lead, to breaching MFN, because this is about how the individual country itself assumes by way of level obligation. That would not necessarily at any point run counter to the principle of MFN. So just clarifying these things, I think, might help us identify where the problem is, to have a good diagnostic view, so that in the reform conversations going forward, we would have an enlightened view about what would be the options to solve the problem really. Because if we try to perform surgery on MFN, we might actually end up with a worse situation for those who complain about MFN, because the problem might not really be there. So I think my plea now is just for a clarifying the principles of what we're trying to deal with, and there are tools within the toolbox to deal with negative trade practices of all sorts, of all kinds. Let me stop here. There's a lot. I think we can devote a whole day for this debate, but I thought just raising some points about the fundamentals would be helpful. Thank you again for the excellent presentations. So back to you, Mario.
Thank you, Hamid. Luke, you have the floor.
Yeah, thank you, Mario. Apologies for being late. I missed Gabrielle's presentation, but I got a chance to look at it before she sent it to us. Before the session, I managed to hear part of Mario's presentation, and also John and Wenhua's. For me, I mean, just to follow up on what Victor and Hamid said, is that when we do a proposal in the WTO, we always try to first define the objectives and where the problems are, and how, and then we see how we can tackle them through this way or the other one. I mean, reading all the three proposals, I'm not sure that I get a clear, at least not for the EU, for neither the US or nor the EU one, whether the objectives are so clearly defined, and also whether the solutions is well serving those objectives. If I could dig a little bit from what Maria and then also EU proposal, first, whether other members are playing fairly, that's one concern. So my immediate thought would be, okay, then we can do it through the ongoing reform about industrial policies, subsidies, government interventions, state-owned enterprises, so on and so forth. So I think that's very much for the level playing field part. If it is about, as some of you mentioned, it's about rebalancing rights and obligations. And my immediate thought would be that we do it through revisiting special and differential treatment, and which is already happening. And we do it through further market access negotiations, be it on goods or service, and so on and so forth. And then some will pay more, some will pay less, the small and vulnerable countries probably. So that's the thing. But tackling directly MFN, which is said by the WTO documents itself that as one of the key principles which provides predictability, certainty, so on and so forth. And the WTO, in quite some recent statements, proudly say that even with the ongoing trade wars, so on and so forth, 72% are still under MFN. So my thought is that if we attack MFN, are we serving our objectives, or are we creating more problems by trying to solve some problems? So that's my thoughts immediately. Last point is I agree very much with what Hamid said, is that we need a conversation, because through this we can all clearly see that be it on level playing field, be it on rebalancing rights and obligations, the divergence is rooted in much deeper and structural problem. So I think we need a fair conversation like today. We are humble experts, of course, but we would hope that the members would do that through their WTO meetings, including the incoming MC14. I understand that DG is trying to organize this kind of so-called structure dialogue among the ministers. So I think those are the things that they should sit down and discuss seriously, and probably would find the way forward. So I'll just stop here. Thank you very much.
Thank you, Luke. Now Gabrielle and then Sherry.
Just briefly, I think I like what Amit said and Victor about, what is it? What's the challenge? And I'm a bit disappointed that nobody really explained the EU paper, because I kept wondering, where are they going? What is it they want? I wanted to, and I was told it's more flexibility in regulatory measures and plurilateral. That's their goal. I said, oh, well, because it's not exactly what the US wants. So it's clear that we need to understand where are the problems. On the distinction between differentiation and distinctions and all that, it exists, as Hamid said. But what I wanted to say is we should not be, I'm Catholic, we should not be more Catholic than the Pope. In the GATS, we set aside, or the governments develop special approach to national treatment and market access, which are also two of the four basic principles. And what was decided is that these are specific obligations, and if you want to commit, you commit, and at certain conditions. So we can conceive, I think, a situation where developing countries who've been there, or after a certain time or certain conditions, they would have to commit to MFN, but may have to take additional obligations or conditions, or maybe in some circumstances there's no MFN, or you may decide everybody has MFN, but you schedule sort of provisions, conditions, qualifications. And the governments through history, each time they had a difficult task, whether it's agriculture, before GPA, they use schedule to modulate the obligation and adapt them to their circumstances, as it was done for trade facilitation. So we should not set aside completely the idea that MFN may, in some circumstances, be sort of modified. But I think there's a lot of already flexibility. My last point is I think that somewhere all this is related to the tensions between US and China, at least for the US paper. And recently, the International Court of Justice about the principle, CBDR, common but differentiated principle, you had, I don't know, 100 countries, developing countries, saying this means that our obligations are different. And the answer was clear and really good, that the obligation to deal with climate exists for all at the level of their capacity. And the court then says, and this is not only an issue of developing. It's too easy. So this brings us to what Hamid said. Maybe it's an issue of categories. And maybe it's true that just having developing, this is not sophisticated enough for today's reality with digital, where developing countries can be as strong. And I remember the story of Lamy, where Korea is a developed countries in financial service, but a developing in I don't know, agriculture. So I just want to say that I think there's a lot that can be done to adapt to the tensions. But the first point, the one made by Hamid, the broader one made also by Victor, is that what's the problem, especially the EU proposal? And I'm still thirsty about a good response.
Okay, thank you, Gabrielle. John is taking note on your comments, but Sherry.
But John is not EC.
No.
But I will explain what the EC thinking is.
Okay. Okay,
Good,
Sherry?
but I don't want to stand between this EC discussion, but I do want to go back to the point that was made about the different level of attention that is basically being paid to this MFN question as applied to goods or trade in goods or trade in services and IPR. I also been struck by that a lot. It's across the board, but it's also in the area of MFN. And our speaker said, maybe is it because trade outcomes are different? My feeling is it might be because the discussion would become that might part of it, of course. But it might also be because the discussion would become really, really complex, given the regulatory intensity of services trade and the distinction between differentiation. And as Hamid very correctly and importantly pointed out, between the level of regulatory application and discrimination. And eliminating MFN in services would really apply the possibility for discriminatory application for a given level of regulation, i.e. different rules for FDI, for indirect investment, and FDI regulations according to suppliers. And this would do away with all predictability and transparency in services trade, which we have actually acquired under the GATS with a great degree of difficulty in negotiation, which can obviously be improved with a larger number of coverage of service commitments. But doing away with this basic a degree of predictability and transparency, which is critical in services trade, given the regulation intensive nature of this trade, would be highly detrimental, and especially detrimental given the fact that digitally delivered services trade is the most dynamic sector of the world economy and has been for several years. So I agree with what Gabrielle said, that there's already considerable flexibility in the scheduling of services commitments, but at least this key element of predictability and transparency is there. It can be improved, it can be expanded, but I think the MFN question is much more complex than the way it's usually perceived and the way it's usually discussed. And if we do apply it across the board as the way it's written in many cases and discuss the implications for this, I think we'd be in a very different ballgame and situation. I'm not sure that the proponents of all of these, I don't know if they're reforms or discussion papers, have really thought this matter through and the entirety of international trade flows, and particularly the most dynamic elements of trade these days, which is services and digitally enabled trade. Thanks.
Thank you, Sherry. Maria, and then Stuart. Or John, you prefer answer now? Sorry.
Why don't I let Stuart go first?
So I don't know how to stop this. Okay, sorry. John, you prefer? getting.
Stuart,
Huh?
I think that the panelists can talk at the end.
Okay, Stuart then.
Okay, yeah, thanks
No,
very much.
sorry, Maria. I was
No,
sorry.
no, but I said I let Stuart go first. I didn't know if there was going to be any other raised hands, so I can go at the end. Go
Okay.
ahead.
Well, I'll try to be brief because I think there's probably a few people queuing up to speak. But I mean, my basic outlook on this is that for the reasons which I think Gabrielle and John have put forward, you know, and also Martin Wolf has written about quite a lot in the Financial Times over the last couple of months. I mean, we've been living through a period of unprecedented success in the global trading system. So you know, we must be very, very careful what we do. But it's a big worry for me that the US, which designed this system, essentially anyway, now feels that it's not working for it. And we have to be prepared to, you know, pay some attention to that very important point. The problem that we face, I think, is that both the US and the EU are not being specific about what they want. If you read the US paper, you know, it's just they just put a cloud over MFN as a whole, including potentially regulatory arrangements, GATS, and all of that. Maria says, and I take her word for it, that really what the problem is tariffs. Okay, but so what we need concrete proposals. Gabrielle pointed out there are a host of exceptions to MFN already. We could consider adding something to those exceptions, but we need proposals. We need specifics. And it's no good to say we just go in and revisit MFN. It's too broad. We need something that we can focus on much more specifically. We need to define the right areas and see if we can come up. I mean, we mustn't shoot for the moon. We must shoot for something that is achievable, that stands a chance of success. I mean, I think bringing in areas like STT, self-designated developing country status, and rebalancing of tariffs. I mean, I think this may be going too far, but you know, let's have some specific proposals. That's what we lack at present. Thank you.
Thank you, Stuart. Now, John or Maria? Maria.
Happy to chime in if nobody else wants to.
No, John is going to answer the questions or the ideas presented by Gabrielle.
Maria, you go first, and I'll follow you, Maria.
Okay, Maria.
All right. So I'm going to try to comment on the things that have been raised. I may not hear everything, but starting from Stuart and I think somebody else also, maybe Hamid, what is a proposal? I agree with you. There is no proposal in the US paper. I just want to remind everybody, I'm retired. I don't work for the US government anymore. I'm trying to interpret and I'm trying to explain, but also because, again, this is why when I have these conversations, I always say, I know it's difficult, but there are issues here that predate the Trump craziness. So, you know, but yes, no, I agree. I don't think, you know, there is no specific proposal in the US paper. There's that I'm here defending the EU paper, and I can't find it quickly here. But you know, there's only a kind of a procedural proposal in the EU paper, but not necessarily, I think, specific on substance. But anyway, I hope, I wish that maybe the United States will put forward some proposals. But I also just want to say that I hope everybody views it as a positive thing that the United States did put forward a communication, because it means that they are engaged and they want to engage in a conversation. You may not like the conversation and you may not like, but that is, you know, I think that that's a way that that communication has to be looked at. It's not a specific proposal, but I mean, there's a lot in there. But here's what concerns us. So it's a start, but completely agree. There is nothing specific. I do think that because this is, if you are now forgetting what I said before, looking at the Trump administration, I mean, Trump is just obsessed with tariffs. He is. He has been for a very, very long time. I hear when people say the United States created the system, helped create the system. Why is the United States now unhappy with it? I mean, I think that there are a lot of reasons because, again, it transcends Trump. But he's doing the same thing to our country domestically. I'm not happy about that, right? So I think that people, it's natural that you're only focusing on the trade stuff because we're all trade geeks here. But he is trying to reform the United States into his vision, and he's Qatari's vision of what the United States should be. I don't personally agree with that. I think there's other Americans who agree with him, many others who don't, and there we are. I do think that it is, from my perspective, both as a former trade lawyer and U.S. government official, but as a U.S. citizen, the Supreme Court decision on the tariffs is hugely important, not just for the trade in the trade space and for those specific tariffs that were dealt with, but from the perspective of the constitutional separation of powers. Again, a different topic, but again, I'm just trying to, at least from my perspective, when I hear, rightfully people complain, you helped create the system, now you're destroying it. Well, I can say the same thing about the country in a way. Hopefully I'm a US citizen, so hopefully ICE will not show up at my door to deport me. But so I can't explain it because I think America is great and has been great for a long time and doesn't need to be made great again. But so anyway, so maybe I'll stop there. On the point made by Hamid on the services MFN, completely agree. And this is I think there is a lot more finesse, and I haven't really dug into these issues as a technical legal matter in a while, but there is a lot more finesse in the MFN concept in the services space. So kudos to you, Hamid, who helped devise the system, and to all others here who worked on that. Because I think there is a lot more finesse in that concept and the way that the GATS was structured that allows for, allows for those flexibilities, to MFN. They're articulated, and maybe that is what we lack on the goods side. Yes, we have exceptions, but again, here's where all of those who wish for the appellate body to come back, again, all these issues are related and certainly are related in the US view. That the way some of these issues were dealt with, de jure discrimination versus de facto discrimination, that's a huge, huge problem as a former USDR General Counsel resident. There's a lot of problems there. The restraints on how governments can deal with legitimate, and I know that, legitimate in one person's eyes is not, is illegitimate in somebody else's. But, so I think that those are the issues that I think are worth discussing, particularly for, if you want to truly engage in WTO dispute settlement reform. And so maybe it's not necessarily about reforming MFN, GAR Article 1 per se, but it's all the other things that are around it, and recognizing, again, as I said, because I do believe this, there are other foundational principles that are equally important, and I don't think you can put one over the other. When you look at it from a government perspective, it's like, I have something that I need to accomplish, and how do I do that? Again, Trump administration, they don't care about rules. They don't care about domestic rules. They don't care about the US Constitution. So, park that aside, if we can, for at least a couple more years or months. But I do think that we do need to look at, how all these things have evolved. I do think that, I raise the issue of special and differential treatment because I do think that all these things are interconnected from the US perspective, in terms of, if you don't recognize that countries have evolved, then again, we're in a static world that you know, or in a static system that doesn't reflect today's reality. I'll finish with a question by Victor, because I do think it's a great question. I don't think the U.S. I will say I don't believe that the U.S. Business community writ large is asking for reform MFN. I do think that there are the industries that we all know who they are, steel, you know, the steel industry, auto industry. I mean, there are some industries that have been heavy users of the trade remedies, and really it just hasn't worked, right, for them. And there may be many reasons, right? There may be many reasons, but I think that that is where you start seeing some of the discomfort with the system. Maybe again, going back to Stuart, you know, why is the U.S. unhappy? And I don't think necessarily, me personally, that it's because we don't want to see small economies develop. I mean, I do think that Trump is a little power obsessed, but I don't think that that's historically been the, you know, I don't think that that's the core of the issue. Yes, there's a big rivalry out there, and that is the driver of many of these concerns. But you know, but it has been an evolution, and so you know, again, is it about talking about you know, reforming the MFN discipline itself? Maybe not, but it's about them recognizing, you know, or looking at, you know, how can we make it more flexible for member countries to do the things. I mean, you know, you mentioned GPDR, all the environmental regulations that the EU has, you know, that we complain about, the United States has complained about over the years, right? But you know, it's legitimate for the EU to try to accomplish certain things, minimizing the adverse effects on other members. And maybe that's the key, right? It's not about preventing, but minimizing adverse effects. I don't know. I just think that it is healthy, and we should be having that conversation. Sorry to be rambling so much.
Thank you, Maria. We are already when beyond the time allowed that was allocated to us, but we need to know what are the objectives of the European Union, and John offered to explain why.
Yes, I'm sorry I disappointed Gabrielle in not doing so from the outset. It's partly because the EU's objectives are very unclear. As someone who's been involved in the Commission machine for 30 years, I suspect that there was a massive debate and disagreement in the preparation of this proposal to the MC14. A disagreement between those bits of the European Union who believe in open trade and international rules, and those that don't, that the more populist and protectionist sectors in Europe. And that's why you have a proposal which is unclear, which is a complete fudge, but which makes I think the massive tactical error of mentioning the MFN word and suggesting it needs to be looked at. I think that is really the EU has shot itself in the foot big time at the very worst moment in doing that. It's not about tariffs, actually. This is all about China. It's some sectors in Europe, some member states who want to find any way they can. It's very similar to the debate in the US, frankly, the way they can to prevent the continued surge of unfairly subsidized Chinese imports that are hollowing out Europe's industrial base. That's the perception. And there are some member states and some industries looking around desperately for some tools to stop that. But the issue is not MFN. That's about trade defense. It's about anti-dumping measures. It's about anti-subsidy. It's about taking China to the DSU or the MPIA. And it's about taking China at its word in its own proposal that they're willing to look at the whole industrial subsidies debate, although I don't think that will get very far. But it's not you don't need to touch MFN to deal with the problem which Europe is sort of talking about. I think there's a lot of regret in the EU side now that they raised MFN in this proposal. I think this is going to come back to bite us all very badly. A word on Hamid's intervention, if I may. I would simplify what he said by saying that MFN requires differentiation. If you treat identically two products, one which is coming in, one which is unsafe, and one which is safe, if you treat them in the same way, you are breaching MFN in terms of you're discriminating against the safe product. So I think that is a very important point. It's very rarely part of the debate about MFN, but it is there, and I think there's been WTO jurisprudence on that issue. I'm very skeptical, or rather worried, when people say we should have a conversation about MFN, because having been a WTO negotiator for decades, when people say I want to have a conversation, this is Diplo speak for I want to negotiate and screw you at the end of the day. So I think we should be very, very careful about having quote unquote conversations about MFN, and I think it's a much safer ground to talk about SDT, which is recognized as a legitimate issue for debate, including by developing countries.
Thank you, John. Okay, we went through the well beyond the hour allowed us. So before giving the floor to Lou to final words, I recommend to look for you the video, because there has been a very interesting conversation between Gabrielle, Bob, I don't remember who else, but a lot of interesting thoughts there. So look at the video later on. Lou?
Yeah, no, Mara, very simply, thanks a lot to you and also all the panelists for really a good conversation. I think this is what we FMG can offer, and try to trigger probably more discussions among the members. Just one quick point on the next logistic issues. We are approaching MC14, so between now and MC14, we probably will only do one session, which is already, I think, finalized. I think Natalie is sending out the invitations to be led by Gabrielle, and Alejandro is very much behind this, and for the recent dispute ruling between US and China, and we're going to do it early March. And after that, we will probably enter into a kind of resting moment for us, so we could leave the ambassadors and also WTO people alone, so they could focus on MC14. But we will do some internal discussions on MFN, MC14, and other things. Of course, we will not rest really, but. What can I say? I mean, as we are discussing today, situation is complicated, issues are controversial, and MC14 is not looking good, if I could dare say so. So, I mean, all the good wishes for MC14, and I hope they could work out something as a kind of achievement, and FMG, of course, remains ready to help them one way or the other. So with that, I thank you all, and we'll look forward to see you next time and the MC14. So bye-bye.
Okay, thank you.
Bye.
Thank you all.
Bye, Ron.